many times you heard the mantra, don't let Boise become Portland or any other West Coast city they claim is overrun with some sort of social issue? That could also include how a city handles its homeless population. The right to sleep on public property has been litigated many times over, and maybe most famously because of something that happened here in the City of Trees. Martin v. Boise set the precedent for the country in 2018 that being homeless is not a crime, especially if that person has nowhere else to go. But a southwestern town in Oregon wants to rewrite that rule by appealing another ruling all the way to the Supreme Court. Grants Pass banned camping and sleeping bags on public property, and they're ticketing homeless people who break that law. The Ninth Circuit told them they couldn't do that, citing Martin, calling the city's laws cruel and unusual punishment. So could the highest court in the land redecide the law of the land? Here's Andrew Bartline.
The gears on a soon-to-be 200-some Boise bed homeless shelter are finally starting to mesh.
It's such a relief. It's such a joy.
Now years in the making.
3.5.
For Jody Peterson-Steigers.
That's what's required to make sure that people aren't terribly traumatized by their homelessness.
Because history shows they're not always welcome with open arms.
These are real people who really are just trying to survive one night at a time.
And at one point, that survival
it makes no sense.
Was illegal.
It doesn't solve the problem.
Howard Belodoff changed that.
Well, I brought the case. We identified the clients. We identified the issue.
In 2009, the city of Boise enforced an anti-camping ordinance against homeless people. They had no room at the shelters. The case was dubbed Martin versus Boise. Nearly a decade later, Howard won.
You cannot criminalize the status of being a homeless person who needs a place to sleep.
Grants Pass, Oregon decided they would anyway.
The tickets in the courts and the jails.
The Ninth Circuit upheld the precedent set in Martin, but Grants Pass has their eye on higher authority.
They appealed it to the Supreme Court. They don't have to take the appeal. In Grants Pass, they accepted it.
Which is a change of tone. Just years before, the Supreme Court denied a similar case to leave Martin in place.
What message does that send to you now that a previous makeup of the Supreme Court wasn't interested in tackling this, but now today they are? I know the court's changed in recent years.
Well, you answered your own question. It changed. The Constitution didn't change. The analysis didn't change. The ordinances didn't change. The homeless people didn't change. That's the only thing that changed.
And a change in ruling to follow would rewrite the script nationwide for how cities manage homelessness and what rights these people have.
They just have to copy Grants Pass's 3 ordinances and make it illegal and just drive them out of town. You might as well put a scarlet letter on them, and we're going to create a caste system like in India, and they're going to be the untouchables at the lower end.
And it's not hypothetical. People are left on the street. Shelters do get full.
And that's been going on for a while now, particularly in very high heat and very cold heat. There's 20 or 30 people that we can't serve. There's just no way.
And after you're left behind, there's no easy way to define exactly what a home is.
It feels like we're going backward instead of forward.
But for many,
hard capped at 205 based on the conditional use permit.
Home is where you go when you have nowhere else to go. Some nights, that's the shelter. Some nights, the street.
The Supreme Court is hearing arguments Monday. Belodoff is not an attorney in that case, but he does expect the Supreme Court to have a decision made by the end of June. He says it's common for the Supreme Court to clear out their slate and start fresh in July. Howard also adds, or Howard Belodoff, I should say, encampments, Brian, are not a piece of this. This is for like an individual person, people as individuals, and no camping ordinances. Those large-scale encampments you'll see in a Portland or Seattle, it doesn't tackle that specifically, at least it shouldn't.
Okay.
And he says there's nuance to be had here. Maybe you could tackle something like that differently than an individual such as Robert Martin in Martin versus Boise.
I'm sure it doesn't include either somebody who camps a camper on a street and uses that and sleeps there for a number of days. I'm sure that's probably not included that either. It's gotta
That might be part of the nuance as well. I mean,
Yeah.
that's their private property. If you're allowed to park there,
on the street. Yeah.
I'm sure that would be the difference there.
Okay, we'll keep an eye on that next week. That's not the only Supreme Court case that has to do with Idaho that'll happen next week, by the way. More on that next week.